Good morning, friends. I hope the life has been treating you all quite well. We are meeting after a long time, but I assure you that now we would be meeting regularly and we would be discussing the interesting and important issues. I have recently come across a judgment of Honorable Supreme Court which talks about maintenance to be given to a wife post divorce. That led towards various other questions which are of course in relation to income tax. Let me first deal with the judgment of the Honorable Supreme Court. What was the issue? The issue over there was the couple got married in 1997. The couple was blessed with a son somewhere in 1998. Somewhere in 2008 they decided to take divorce. The Honorable the Calcutta High Court has granted a monthly alimony of rupees 20,000 rupees or maybe 25,000 rupees with an annual increase of 5% at an interval of every 3 years. Wife was not happy with that amount. She knocked the doors of the Honorable Supreme Court. The Honorable Supreme Court stated that, or before we go to that, the husband argued that I have already married, I have my parents to maintain, I have my other commitments. The Honorable Supreme Court stated that nothing doing, the maintenance has to increase. 20,000 is not sufficient because you are earning an amount of roughly around 1,60,000 rupees a month. So the maintenance has to be 50,000 rupees, more precisely when the wife is only dependent on the maintenance. Of course, each case is a different case and each facts are different. Straightway, the ratio cannot be applied to the other cases. Here, the crucial part was the wife was entirely dependent on the maintenance. Second important part is the marriage lasted for at least 10 years. So if let's say the marriage lasted only for 2 years, 1 year, then probably the ratio may not be applicable. The ratio once again would not be applied if it is found by the Honorable Court that wife was capable of earning and she's simply stopped earning precisely just to seek the maintenance. Probably court may take a different view. Be that as it may, let me first take you to the judgment and then the interesting issues which came to my mind and for which I have found out some other judgments as well. Let me take you to the particular observation of the Honorable Supreme Court. It is in the case of Rakhi Sadhu Khan. It is in the case of Civil Appeal number 10209 of 2024. What they have said that in our considered opinion, a sum of rupees 50,000 per month would be just, fair and reasonable to ensure financial stability for the appellant wife. The amount shall be subject to an enhancement of 5% every 2 years. As regards the son, now aged 26 years, we are not inclined to direct any further mandatory financial support. Now the crucial part begins. However, it is open to the respondent husband to voluntarily assist him with education or other reasonable expenses. We clarify that the son's right to inheritance remains unaffected and any claim to ancestral or other property may be pursued in accordance with law. This is really crucial. Now let's take a case that there is a husband's HUF. The HUF consists of husband, wife and a son. There is a divorce. Since there is a divorce, of course there is a severance of relationship. So wife would definitely cease to be a part of the husband's HUF. But the son, despite living with the wife, despite the custody is with the wife, will still be a co-partner, will still form a co-partnery with his father and he would have the right in the property of the HUF. Number A. Number B. Assume a case that, let's further extrapolate the situation, assume a case that now the husband remarries. The other wife would now become a part of that husband's HUF. So the husband's HUF will have now husband himself, son from the previously divorced wife or previous first wife and second wife. Assume a case that the second wife has a son or daughter from her first marriage. The son or daughter from the first marriage will not be a part of the husband's HUF. However, if the husband legally adopts them as per the Hindu Adoption and Maintenance Act, in that case, the adopted son and daughter, which are the biological son and daughter of the second wife and the first husband of the second wife, will now be the member of the husband's HUF. So now the husband's HUF would consist of husband himself, son of husband from the first wife, second wife, and the legally adopted son or daughter of the second wife from her first marriage, which have now been adopted by the husband. So this all would form the members of the HUF. Of course, if we refer to the Hindu Adoption and Maintenance Act, once again it has been clarified, upon the kid being adopted by the adoptive parents, the biological parents, his relations with the biological parents would come to an end. So certainly, so there the relation would come to an end, and the adopted son will have a right equivalent to that of a biological son. This is what I could find out from the other legal judgments and the other material which was available. Now that leads me towards one more interesting question. Coming to the alimony. Would this alimony amount of 50,000 rupees which a wife is receiving, would that be taxable or not? So alimony can be a one-time alimony or it can be a monthly alimony, so you can say a recurring alimony. What would be a tax statement? There is no direct provision in the Income Tax Act dealing with this issue. But then if you go to the judiciary, we have got a Bombay High Court judgment. We have got a Bombay High Court in the case of Princess Maheshwari Devi versus CIT 1984, 147 ITR 258, 1983, 12 Taxman 220. In this particular case, what has happened is the assessee was married to Maharaja of Kota. The marriage was annulled by a decree of nullity of marriage. Under the decree, the assessee was granted monthly alimony and the lump sum alimony. The Bombay High Court held that the monthly alimony amounted to a taxable income in the hands of the assessee. However, the lump sum alimony was in the nature of capital receipt. This case was also followed by the Honorable Calcutta High Court. In the case of Calcutta High Court, in the case of Srimati Roma Sengupta, once again, a view has been taken that if it is in the nature of a lump sum alimony, it will be a capital receipt. Let me now take you to the third decision, which is in the case of Delhi ITAT. The facts are interesting in this case. Husband agreed that I will pay you boss monthly remuneration, I will pay you monthly alimony. Then husband chose not to pay for any reasons. Wife said, boss, I will take you to the court. You agreed to pay, you are not paying me. Husband said, do one thing. You relinquish all the rights of our past accumulated alimony, past accumulated monthly amounts which I was supposed to pay, I have not paid, as well as the future claim. You relinquish everything, and I will pay you one time. And finally, he paid that one-time amount. So the issue was that one-time amount, would that be taxable or not? Once again, the Delhi Tribunal has held that this one-time amount is for relinquishment of her past claims, for the claims for the past period as well as for the future claims. So it will not be caught by section 56(2)(6). At the time 56(2)(6), now we have 56(2)(10). It won't be caught by 56(2)(10), and that's why it won't be taxable. We have got the Delhi Tribunal in the case of Assistant Commissioner of Income Tax, Circle 32(1) versus Meenakshi Khanna, 2013, 34 taxman.com, 297 Delhi. In the instant case, though the assessee was to receive monthly alimony which was to be taxable in each year from the conclusion of divorce agreement, but the monthly payments were not received and therefore were not offered to tax. The receipt by the assessee represents accumulated monthly installments of alimony which has been received by the assessee as a consideration for relinquishing all her past and future claims. Therefore, there was sufficient consideration in getting this amount. Therefore, section 56(2)(6) is not applicable. We have now 56(2)(10). Same analogy would be applicable. It won't be taxed. Thank you very much, friends. I assure you that my videos would be reaching you regularly, and this time we will be meeting at regular intervals. Thank you very much. Wishing you all a great time ahead. Thank you.